The chair calls Jeremy Newman. Go ahead.
Chairman, members, my name is Jeremy Newman, Policy Director at the Texas Homeschool Coalition, testifying in favor of the bill. This is a bill that we actually brought to Representative Laubenberg, and as I mentioned earlier, THSC lobbies on behalf of parental rights issues because we see it as the foundation of your right to homeschool in the first place. And so for this particular issue, I would maybe describe it as the most no-brainer issue that I think this committee could adopt, because what we're saying basically is that when you're sued the second time through a modification suit, you should be provided the same protections that you had the first time. And so what happens in these cases is that you get sued the first time and you're entitled to the protections under the law of the presumption, and then they come back and sue you a second time through the modification suit, and all of a sudden you lose the presumption. And so our position is that you shouldn't lose your legal protections because someone sued you twice. So a couple points that I would make here specifically is that, actually Julia mentioned this in her testimony, the Troxel decision would seem to require this already. And what's interesting is that, to my knowledge, the predominant case on this issue is In Re VLK, which was the Texas Supreme Court decision in 2000. It came out 17 days after the Troxel decision did. The Troxel decision is the U.S. Supreme Court decision that requires that courts recognize that a fit parent is acting in the best interest of the child, and you must overcome that presumption before you're allowed to overrule the fit parent's decision. And so the fact that they came out 17 days apart might explain the fact that the Texas Supreme Court decision makes no reference of Troxel. And the Texas Supreme Court decision really spoke to the fact that because it's not stated in the statute, they're not going to recognize it. Well, according to constitutional case law, you should have to recognize it. And so I've spoken to a few judges around the state who tell me that they recognize a presumption across all of these cases from a constitutional standpoint in Troxel, but they also know judges who don't. In fact, I spoke to one judge in Houston who said that he would estimate that about 40% of the cases that he takes that are on conservatorship issues come through the modification statute. And because it comes through modification, and if he wasn't a judge that recognized the constitutional presumption, then the parents would lose that presumption just because it came through a modification statute. And for judges who don't recognize it, then every case that goes to that court through the modification statute does not have that protection. So we really see this as a no-brainer, that if you're protected the first time, you should be protected the second time. And I'm happy to answer any questions the committee has.
Thank you. Questions? Okay, no questions.
Thank you.
Thank you, Mr. Newman, for your testimony.